Mr. Johnson, appearing in person and pro se. Your name tag on your uniform says Johnson, so I presume you are Mr. Johnson. Now, sir, if you could get right in front of that microphone, thank you.
Can you hear me?
I can. Sir,
Yes.
you're charged in count 1 with speeding 82 miles per hour in a 65 mile per hour zone. That is a traffic infraction. It is not a charge that carries any jail time. It has a scheduled fine. 82 and a 65 is $87, but then there's also 108 court costs. In count 2, you're accused of operating your motor vehicle without proof of insurance. Now, if you had insurance but just couldn't find it, you can get the proof to the county attorney and she'll probably dismiss that charge. If, in fact, it had lapsed or something was happening so that you didn't have insurance on the vehicle at the time being January 4th, 2024, that is a B misdemeanor. The maximum penalties as far as jail time would be 6 months, although probation is usually granted. There is a mandatory minimum fine the court must impose of $300, but it could be as high as $1,000. You do have the right to hire any attorney of your choice. If you cannot afford an attorney, you can apply and see if you qualify for court appointed. You can waive your right to counsel and represent yourself. Another option, you might be able to apply for diversion. That is where you apply, and if the county attorney approves you for diversion, you would pay agreed upon fines, costs, get your insurance current, and pay a diversion fee, and she'd dismiss the charges and keep them off your record. If you want to talk about diversion or anything else with your attorney, you certainly will have the opportunity to do that. Your pleas, you have a choice of pleas. You can plead not guilty, and we can set this for trial at a later date. You can plead guilty, admitting the charge, and we would proceed with sentencing. Or you could plead no contest, which is neither admitting nor denying the charges, but you'd still most likely be found guilty and we'd proceed to sentencing. If you want to look into diversion, we'll enter a not guilty plea to give you time to do that. You can always change your plea, but once you're convicted, pre-trial diversion is off the table. So
probably not eligible for diversion based on his driving record.
Oh, okay. Well, do you want to talk to an attorney then? And
Buckle up, guys. Today we are going to witness a courtroom clash like no other. An active duty soldier walks in carrying not just his uniform, but a sovereign citizen script that challenges every word from the judge. The case may look like a simple speeding ticket and no insurance, but it quickly spirals into a heated battle over law, authority, and defiance. This intro sets the stage for a storm that is about to unfold inside the courtroom.
so if I were,
Well, Your Honor, I simply do not understand the nature and cause of the accusation with regard to the jurisdiction of the venue and nature of this action until the prosecutor properly alleges them there. I cannot enter a plea to the charge until I have the opportunity to raise a meaningful defense on my behalf.
all right, I will then, since you cannot enter a plea today, I will enter a not guilty plea for you and give you
I
time.
object, Your Honor. I object to you entering a plea to me because I must understand the nature and cause of these accusations. So I do not agree to you entering a plea on my behalf.
Well, your position is taken and I'm still going to do it. I will note your objection for the record, but I'm going to enter a not guilty plea.
Well, I object to you
Your
entering a plea on
objection
my
is
behalf.
noted. Your objection is noted, and if the time comes, you can appeal that to the Court of Appeals. Now, on the issue
Well,
of
who is,
attorney,
Your Honor, I would like to ask, who bring these charges against me? I should have the right to
all
question.
right, we're not going to have this debate right now. I've told you your charges. I've told you the state of Kansas has filed those through its attorney, Jill Gillette. Now,
Well, I would like to
okay,
call
I'm
the
going
state to the, I would like to call the state to the stand, Your Honor.
We're
The
not doing that,
state bringing charges against me, who's it, how did I injure the state?
All right, this is your first appearance. I advise you of your rights. I advise you of your charges and possible.
Your Honor, I object to the proceeding, for I do not know the nature and cause of the
I'm
proceeding.
entering a not guilty plea. Missy, when is?
I object to you entering I object to you entering a plea on my behalf. I do not grant you that right.
Missy?
The court date,
You're supposed to act as a trustee.
Sir, you need to stop. You're being in contempt of court. You need to stop or I'll have the.
The judge lays out the charges with calm authority: speeding and no insurance, penalties explained clearly, even offering a chance at diversion to keep the record clean. But instead of moving forward, this is where the seeds of conflict take root. Johnson is presented with options: plead guilty, not guilty, or no contest, but his mindset isn't about traffic violations. It's about rejecting the system entirely, setting up the clash that defines the rest of the hearing.
For if you're making a threat towards me, then
Okay,
that's
if he's going to
urging
keep
me to
being
perform in your
contentious, I'm going to
court.
have you take him into custody on contempt.
Then that would be illegal search and seizures, Your Honor.
Wouldn't you need to go back?
It will.
All right,
It's
Missy.
false
I
imprisonment.
want you to stop talking or you can go upstairs to the county jail. Now, do you want to go to jail tonight?
Your Honor, again, Title
Deputy
40,
Miles, could you
let's
come in and
see.
assist the defendant?
September 27th at 9 o'clock will be the court date.
September 27th, you said 9 o'clock?
Yes.
9 a.m. You must be back here, sir, in person at the courthouse, or you will be arrested for failure to come to court.
Your Honor.
Now, that deputy there is going to take you into custody if you cannot control yourself through the remainder of this hearing.
I'm not doing anything. I'm just enforcing my right, Your Honor.
All right, so your first right is to have a hearing date, and that is September 27th, 9 a.m. The
Your
second
Honor, I
right,
also have a right to understand the nature of this. I have a right to understand the
all
nature
right.
of the cause.
If you don't want to listen to me, you can go to jail.
Is that your order, Judge?
Do you want to hire an attorney or apply for court appointed?
No, I do not. I don't need to hire an attorney, Your Honor.
You want to represent yourself?
I don't need to hire an attorney. I would like for you as the judge, Your Honor, to explain to me the nature and cause of the.
All right, I'm not going to appoint an attorney if you don't want me to. If you want, you said you don't want to hire an attorney. If you want to apply for court appointed, the officers have forms there that you can fill out. If
I
you
just
don't
want to
fill them
understand the
out,
nature
I'm
and
going-
cause.
If you don't want to fill one out, I'm going to assume you don't want an attorney. And then if you come to court September 27th at 9 a.m., you're going to be representing yourself if you don't hire or apply for court appointed. And so you've got the third issue. Does he have a bond? Looks like you do because you failed to appear February 27th at your first appearance. So bench warrant was issued, bond was set at $1,000 cash for professional surety. Looks like that was posted. Looks like you made a cash bond of $1,000. Does that sound right? You put up $1,000 cash back in July 12th?
Here's where it shifts. Johnson refuses to play by the rules, demanding a declaratory judgment and questioning the court's authority. He argues he can't plead until jurisdiction is properly alleged, a classic sovereign citizen tactic. The judge remains firm, entering a not guilty plea on his behalf. Johnson objects immediately, refusing to accept it. This is no longer a standard arraignment, it's the opening round of a battle between courtroom order and sovereign chaos.
Now, you're wearing a U.S. Army uniform with the name Johnson on it. Are you in or have you been in the United States military?
Your Honor, I'm still trying to understand the nature and cause of the allegation, Your Honor.
All right. If you can leave the courthouse now without any further disruption, I will let you do so. And I'm going to have those officers escort you to make sure you do so. So, Ms. Gillette, anything further?
Your Honor, it is your oath to explain the nature and cause of the allegation against me. Are you failing to do that?
All right, you can either walk out the front door with the officers, or you can walk upstairs to the county jail with the officers. The choice is yours. Either leave.
Your Honor, I'm trying to understand.
Or leave disruptively.
I'm not being disruptive. I'm just trying to understand the nature and cause of the charge.
All right, officers, I'm gonna close.
What am I doing? I'm sitting here trying to understand the charge.
If he gives any more grief.
All I'm asking is to understand the charges. This is for the record. You said it's for the record, so I'm trying to understand what am I being charged?
The charges. Goodbye, sir.
I just want to understand the nature and cause of the charges, Your Honor. That's all I ask. It is your oath to give that.
With you. If you tell me what kind of questions you have, I'll be happy to answer them. But I've already told you.
Okay. Under what jurisdiction is these charges being brought to me under?
All the
State of
jurisdictions.
Kansas is charging
All
you
of them.
82 and a 65 and operating in a motor vehicle without liability insurance on January 4th, 2024 in Greenwood County, Kansas. You failed to appear for your first appearance, and a bench warrant was issued, and you were arrested, and you made a bond of $1,000 cash or surety, posting a cash bond. Now you have to go to court, and you have to answer those charges. You can
Your Honor,
have a trial if you like, and the burden will be on the state of Kansas to either prove or disprove. If they can't prove it beyond a reasonable doubt, you're let go.
Well, I'm still trying to understand what jurisdiction am I being charged under, Your Honor? That's all I'm trying to understand.
You're being
All the
charged under the
All of
jurisdiction
them.
of the state of Kansas under its criminal.
But according to the Constitution, there are only two
All right,
jurisdictions.
we'll have that on a later date.
The tension snaps tighter as Johnson insists on calling the state to the stand, demanding to know how he injured Kansas itself. The judge tries to keep order, but interruptions pile up, turning this into a spectacle. Warnings turn serious when the judge mentions contempt of court. Johnson throws out words like false imprisonment and illegal seizures, showing just how deep he's committed to the script. The courtroom edge is sharp, and consequences are closing in.
I have a couple. I have a Danny Johnson, and well, don't I have her on here? Oh, she's Stasha Carter. Do you go by Johnson also?
Okay, so I'm here for Danny Johnson.
Oh, are you the attorney?
I'm a representative for him.
What does that
And
mean?
that means I'm his wife, and we sent
Okay, are you an
documentation.
attorney?
I'm an attorney, in fact.
You're not an attorney at law?
No.
Okay. So when
So-
you say
so
you're an
Mr.
attorney, in fact, you're not an attorney, but you're here on his behalf as a citizen. Is that
No, I'm
right?
not a citizen. I'm not a citizen. But let me state for the record, Mr. Johnson is under doctor's care. He's in recovery. We sent the documentation over to the courts to show that, to show proof of that. We also reserve our rights to any and all reproduction of or distributing of videos on social media platform.
Well, this is awkward.
And we request the matter to be rescheduled at a later time when he can get through his recovery period.
All right, Mr. Johnson failed to appear at his first appearance, February 27, 2024. August 13th, 2024, he appeared. We took formal first appearance. He entered a not guilty plea. Actually, he objected, I think, to just about everything that we did. He was argumentative, disrespectful, interfered with court proceedings, I believe he
I
was
object, Your Honor. I think he was
Stop,
just,
stop.
he was-
You don't have any standing here today, Miss Carter, because you're not his lawyer. You're not him.
I'm not Miss Carter. I'm not Miss Carter.
Then why does your screen say Sasha Carter?
That's what it says, but I'm not Miss Carter. And it says
Who are
Sasha.
you? Who are you? Before I disconnect you from these proceedings, because you don't have standing to be here. What's your name?
Well, again, Mr. Johnson is under Dr.
Do you want to
Mr.
tell me
Johnson is
your
here.
name?
He's here. I've already gave you my name, ma'am. I'm his
Well, then
wife.
say it
I'm
again,
Miss
because I
Johnson.
must have missed it. What's your
Miss
name?
Johnson. Miss Johnson.
What's your first name?
Nicole.
How do you spell that, please?
The judge draws the line, either comply or face jail time. Johnson, unmoved, keeps repeating his rhetoric, rejecting even the need for an attorney. Meanwhile, the judge explains his bond, reminding him he already failed to appear once and only avoided sitting longer in jail by posting $1,000 cash. But instead of seeing the gravity, Johnson digs deeper into defiance, refusing counsel and leaving the judge to prepare for the inevitable collision.
Nicole.
Nicole Johnson, and you said you're his wife. Is that
That's
correct?
correct. That's
You're
correct.
his legal wife. Okay. Now, if you'll let me continue, and if you won't, then we'll have to remove you from the proceedings. On August 13th, 2024, he became, as I said, argumentative, disrespectful, and interfered with the court proceedings. I found him in contempt. He was arrested, and he was to serve 24 hours in jail. And then, as I recall, the military put a hold on him, and because of whatever reasons, he served more than 24 hours. But he was told to be back here September 27. And on September 27th, there was an issue that he either was or was not receiving medical service. And he wanted a continuance, and we ultimately continued it to today. Now, that's been a month ago. And you say he's still under doctor's care and can't be here today, or is that, what were you trying to explain there?
What I was expressing, ma'am, is that he was in surgery on the day of the court date. He had
30 days
actual
ago,
surgery.
he was in surgery. Okay.
Correct. The doctor put him under doctor's orders to stay on bed rest. And that's where he's currently residing at, on bed rest. And we sent in the documentation to the courts and the doctor. The doctor notified the courts that he's not to appear because he can't travel and he can't fly due to his surgery.
And we've made it clear to him that he can appear by Zoom. So I'm going to issue a bench warrant, bond forfeiture.
Hold on one second, ma'am, because he is here. He can hear you, but it's
Well, then put him on here.
Oh, he's on here, but he's in a recovery bed, ma'am, and it's a violation of his rights, his HIPAA rights, to be shown and be broadcasted all across social media as far as
bench warrant, bond forfeiture, no bond, hold.
This is Johnson's last chance to walk away free, but he won't take it. The judge spells it out: either exit calmly or head to jail. Johnson keeps circling back to the same questions about jurisdiction, refusing to hear the answers already given. The frustration in the courtroom is palpable. What could have ended quietly instead stretches into a showdown, with the judge finally adjourning while deputies stand ready to escort him whichever way the situation breaks.
But I have reached out to the courts. I have had the hospital reach out to the courts in reference to my procedure and my process. I have requested a continuation. I have also sent in letters to request evidence from the case to continue the case prior to these procedures that I have not got a response back. So
certified mail.
I sent it out registered mail that the courts received, I think, on the 23rd, in requesting evidence of the case to continue prior to my surgery, but having the surgeon
it's an unforeseen circumstance.
Ma'am, I want you out of the case now. You're not his lawyer. He's talking, he's representing
Ma'am, the
himself.
creator,
You're out.
the creator made me his wife, and
I will find you in contempt of court.
ma'am.
Stop talking, Miss Johnson.
Okay.
Now, both of you stop for just a moment. Miss Gillette, you haven't had a chance to say anything on this. Do you wish to be heard?
Because you're acting like the attorney.
I'm acting like the court, and you owe me $50, ma'am, for contempt. And if you have another outburst, it's going to go up, and it will be enforced. $50 direct contempt by Nicole Johnson for her interruption of the proceedings. Ms. Gillette, do you wish to be heard?
Good luck with that.
Ms. Gillette?
Sorry, I was making notes, Your Honor. In this matter, there have been lots of issues with Mr. Johnson. There is a letter here. I don't know if it came directly to my office or through the court. It's through the court because it was filed in the court file of
All right, so when
his-
you say through the court, you mean it went to the clerk?
It went to the clerk
Okay.
and was file stamped. There
And it
is
may or may not have made its way to my office, but if it has, I haven't seen it. For the record, go ahead, please.
there is a note from
Even after adjournment, Johnson can't let go, pressing the same demands and ignoring every opportunity to stop. The narrator cuts in, mocking his stubbornness and reminding us that one wrong word can turn freedom into handcuffs. It's a masterclass in self-destruction, every warning ignored, every out refused. The judge moves on, but this man's battle isn't over yet. Because now, his wife steps into the picture, and if you thought things were messy, it's about to get worse.
Put Carter on your screen if you're not Carter.
Ma'am, we made the point to be here in court today, ma'am.
You
And that's under the
talking.
unforeseen circumstance. He's still
All
here.
right, I'm going to end this talk. This court is over. Bench warrant if you don't stop and get out of it. If you don't want this bench warrant, you be out of this conversation and let me communicate with the defendant.
Ma'am,
Obviously,
there's no
Mr. Carter doesn't have any control over
convicted of
you.
anything.
Okay, Mr. Carter, I'm going to have to end this court because the woman won't shut up. And I'm going to have to leave a bench warrant. If you can get her to shut up and stay out of the conversation, you and I, sir, can have a hearing. Now, okay, how much time do you need this continued, Mr. Carter?
The doctor can send over the information.
I would request.
Mr. Johnson, I'm sorry, Missy, can you get that Carter out of here?
Hey, I'm trying to explain to you. The doctor told me it's going to be 3 to 6 months for my recovery.
3 to 6 months.
I had a T10, T11 procedures. So it's a middle back procedure. Like I said, I haven't even started physical therapy yet.
Do you have an attorney, or would you be willing to take a court-appointed attorney?
As far as the attorney, all I would coming to do is, because I'm on medication.
Now enters Johnson's wife, Nicole, determined to represent him but armed with the same sovereign rhetoric. She rejects citizenship, insists on reserving rights, and demands rescheduling. The judge shuts her down. She has no standing, she isn't his lawyer. What follows is a tangled back and forth of excuses, contempt references, and defiance, proving the sovereign ideology runs deep in this household. This bizarre courtroom saga leaves one clear lesson: defiance only digs a deeper hole. And that's all for today's video. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next one.